Welcome back to the Law Stash channel. My name is Anton Vieltsin, and I'm a criminal defense attorney in the Southern District of California, here in San Diego. In this video, we'll be dealing with firearms. Of course, you're well aware that Congress has enacted a bunch of statutes dealing with firearms, and certain individuals are prohibited from possessing firearms in the United States. Of course, you already know a statute, felon in possession. I have a number of videos dealing with that statute. Today, we're going to be discussing a different topic, whether an immigrant is permitted to possess firearms in the United States. In this video, we're discussing a recent Ninth Circuit case, United States versus Geer. Now, this case deals with firearms and immigrants. As you can imagine, immigration and criminal law sometimes go hand in hand. So let's go ahead and take a look at this case. Of course, we know under 922G, United States Congress prohibited a bunch of people from possessing firearms. We know that felons, illegal aliens, and other specified groups of individuals are prohibited from possessing firearms in the United States. Non-immigrant visa holders are in this other specified group. What does that mean? Well, let's talk about the case of Mr. Geer. First, we're going to talk about the facts, and then we're going to get to the law. Mr. Geer is a native of Australia. He entered the United States under E3 visa to work at a solar company. Essentially a non-immigrant visa. What does that mean? It means that through this visa process, he's not going to become a citizen of the United States. It is simply a visa that allows somebody to work temporarily in the United States. And once the visa expires, they have to leave. This is a non-immigrant visa. Eventually, his visa got converted to an H-1B visa, which is very similar to the E3. He then had a divorce in Australia, and through the divorce, there was a separation of property, and he brings his rifle in the United States. Of course, he disassembles it and gets it shipped. So the process is legal. But here's the question. Is he allowed to possess this firearm in the United States? So we'll take a look at that. But here's what happened next. He gets fired from his solar company. He gets another H-1B visa where an immigration attorney helped him fill out the documents. Essentially, he created a company with his new wife. And with that company, he started working. He bragged to his co-workers about possessing a rifle. Department of Homeland Security starts investigating. They eventually receive a search warrant signed by a magistrate judge, allowing them to search Mr. Geer's home. There's no issues with the warrant. In this case, we're simply dealing whether he's allowed to possess a firearm. When the officers come to execute the search warrant, they're greeted by Mr. Geer. They first ask him about the firearm. He says that's not true. Because he's not a United States citizen, he knows that he's not allowed to possess firearms. So he says he doesn't have one. Eventually, the agents tell Mr. Geer that they have a valid search warrant to look in the house. And of course, the story changes, and Mr. Geer then tells the agents that he does in fact have the rifle. It is in a safe in the garage. The agent executes the warrant, they find the firearm, and Mr. Geer gets prosecuted under 922G as a non-immigrant visa holder possessing a firearm. The government says that non-immigrants cannot possess firearms, and we know that. But the question becomes, what are the jury instructions? At trial, the jury was instructed on three things. In order to convict Mr. Gear, they had to find that he knowingly possessed that rifle, he shipped or transported it in a foreign commerce, making it a federal crime. And number three, that he was in the United States as an alien who had been admitted into the United States under a non-immigrant visa. So those are the facts. Why are we in the Ninth Circuit? Well, because Mr. Gear appeals. At trial, the government only showed that the third element is satisfied because we know that H-1B visa is in fact a non-immigrant visa. He argues that the government should have proved that he actually knew that it was a non-immigrant visa. It is not enough to basically prove the label. You have to get into the mens rea, behind the mind of the individual. See what the defendant knew. And the Ninth Circuit says that's correct. Hey, I hate to interrupt, and I know we're kind of on a roll, but have you subscribed to my channel? If you haven't, click on the button below where it says subscribe, so later on you can watch my awesome videos every week. I post every Wednesday in the morning just for you. Subscribe. It's free. Eventually, I might have to charge you, but this time it's free. What are you waiting for? Click the button and subscribe. Thanks for watching. Let's get back to the video. Under Rehaif versus United States, defendant knew he belonged to the relevant category of persons barred from possessing firearms. We have to show that he knew that he belonged to this group, and not simply that we know that he belonged to this group. And then there's a bunch of questions. Well, at trial, a number of people testified. But the Ninth Circuit says the label, the fact that his visa stated that it is a H-1B visa, doesn't prove that he knew that it was a non-immigrant visa. But we do know that there was an expiration date on it, which suggests to Mr. Gear that he's not permitted to stay here indefinitely. He also bragged to other individuals that he had the rifle. He also told the agents who were arresting him and executing the search warrant that he was not allowed to possess firearms. So from those facts, we know that he knew that he was not allowed to possess firearms. So even though he's right, the Ninth Circuit says that yes, when you go to trial on 922G, the government has to prove not only that you're a non-immigrant in the United States, but that you knew that your visa was a non-immigrant visa. Why does he still lose? Well, because anytime we're on appeal, we have to look at the standards. And here, the standard is plain error, meaning that he has to show a reasonable probability that the outcome would have been different if there was no error. But here, the Ninth Circuit says that even though he's right, they can't imagine that the trial would have been different. With all the evidence about his knowledge, the jury still heard about it. And so even if they were instructed on it, there was enough to convict him. And for that reason, he loses at the Ninth Circuit. What is the lesson for us here? Don't always look at labels. We always have to look at the mens rea, the mental state of the defendant. We also know that employers often lure individuals into the United States to work for them, and they tell them that through this process you can eventually become a citizen of the United States. But that's not true. Depending on your visa, sometimes you're allowed to become a citizen, sometimes you're not. Non-immigrant visas are non-immigrant for a reason. I hope you enjoyed this video. I also hope you now understand what are the types of individuals who are prohibited from possessing firearms in the United States, and that you understand how our process works at trial, that there are arguments to be made during trial and then later on appeal if you lose. I hope you enjoyed this video. Click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you'd like to purchase one of these t-shirts, go on my website at losthash.com/merch. Thanks for watching.